Good morning. We are back by popular demand, so welcome to another in our series of our weekly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Just wanted to thank you all for your positive comments about these sessions, and that's obviously why we brought them back to you, and we're going to continue to run them each Friday on Teams at 10 a.m. While there's still interest in us doing so. Thank you for signing up to them, for tuning in each week, also for sending in your questions. We've had so many questions from you, which has been fantastic. We've tried to get through a lot of them, and we'll try to get through even more through these sessions, and of course for watching the video online afterwards. So thanks for that. As with previous weeks, with previous sessions, the employment team will answer 3 questions, be that either COVID-19 related or otherwise. Our speakers today are myself introducing and associates Ailsa, Hobson and Catherine Hope. So I'm just going to move this screen on. So without any further ado, I'm going to pass you straight over to Catherine. She's going to start and deal with question 1 of 3. I'm just moving Catherine onto the screen now so you can see her. Catherine, good morning and over to you.
Thanks, David, and good morning, and thanks for joining us again on this Friday morning. I hope you've been able to enjoy some of the weather in some shape or form. It looks like it's really nice again today. So we've had a number of questions. One thing that's come up quite a lot is the question on flexible furlough and what that means. So I'm just going to start with giving a brief overview of what that is and what the options are to employers. This was something that was first announced by the Chancellor on the 29th of May, this idea of a flexible furlough scheme, to be introduced from the 1st of July. And it was something that the guidance was updated in relation to on the 12th of June. So in terms of from a basic perspective, it's applying some flexibility to the furlough leave that you have been able to put your employees on furlough leave and claim back some of their wages subject to the current cap under the government's job retention scheme. And what it means is that employees can remain on furlough leave or be put back on furlough leave, and they can work part-time, some of their part-time work, and they can also remain on furlough leave for the remainder of their normal contractual hours. And how does that work? In terms of who it can apply to, it can only apply to employees who you've previously put on furlough leave for at least 3 weeks prior to the 30th of June. So the last date on which you could have put someone on furlough leave for the first time was the 10th of June. Now, there is an exception to that. That's where you've got employees who are coming back from family-friendly leave, such as shared parental leave, maternity leave, but only as long as you have made use of the scheme in respect of your other employees before the 30th of June. So in terms of how it works, the guidance confirms that you can use any work pattern. A flexible furlough arrangement can be in place for any amount of time. For example, if you've got someone who's full-time, they normally work Monday to Friday, 9 till 5. You could decide you want them to come in on a Monday and Tuesday and remain on furlough leave for Wednesday, Thursday, Friday. So they're working 40% of their hours. Another alternative is you could have them on a rotational basis. So the first week they're working Monday and Friday, working again 40%. Second week you're having them in for Tuesday, Wednesday, Thursday, again working then 60%. And you could arrange that if it works for your organisation in a way that they're rotating those hours with another employee. So you've got someone in every day, and that's a way of using the scheme. Alternatively, another option would be you want someone in every day, but you don't need them in for their full contractual hours. So you might say, we want you to come in every morning, Monday to Friday, but you're being on furlough leave for the afternoons. So there are a number of options there. And obviously you'll have some employees who are already working part-time, and you can bring them in on various shift patterns that work for you. It's entirely flexible in that regard. There's no limitation. In terms of what you can claim back from the scheme, you can then claim them back for the hours that an employee is not working. So you need to pay them their full pay for the hours they're working for you, but you can continue to claim under the job retention scheme, obviously subject to the cap as it proceeds, and obviously there are changes to that in the coming months. In terms of further changes, there are some of the restrictions. So at the minute, although there's no limitation on the time period for an arrangement, there is a requirement that a claim, when you're making a claim, it has to be for a claim period for a 7-day period. Now, the guidance There isn't much detail on this, but my understanding is that, for example, again, going back to that full-time example, if you've got someone who ordinarily works Monday to Friday and you want to bring them back, say, on a Monday and a Friday at the beginning, when you're submitting the claim for them, you'd have to do a claim for a 7-day period, let's say Monday to Sunday, and claim for the periods of the days of that week, Tuesday, Wednesday, Thursday, that they're not working. So that's a 7-day period that you're claiming for. You couldn't, in an alternative claim for, say, submit a claim for Monday to Wednesday, and then so Tuesday, Wednesday, and then submit a second claim for the Thursday and Friday. It has to be done in that 7-day period. But I would say we are hoping there'll be some more guidance in that respect, because it's not entirely clear. The other thing is you need to put a claim in. It has to be within the same month. Now, just going back to actually the 7-day periods, the exceptions to that are if you are making a claim for a period that includes the first day of the month or the last day of the month, and you've claimed already for the period immediately before that. So do look at the guidance in that regard. In terms of if you decide to take up this the flexible furlough scheme, you do need to again agree that arrangement with an employee. Again, it's a contractual variation, and the requirement is that you need to again document that in writing as you have done for the furlough leave. So it's going to be useful to put a new flexible furlough agreement in place to set out the conditions and the terms that you've agreed and the arrangement there. What I'd also say you need to do is make sure you've got a system in place to document what hours they're working and what hours they're on furlough leave, because another requirement is that you need to keep a written record of those hours, the hours they're working, their hours they're on furlough. And again, for the written record, you need to keep that for the 5-year period, as you currently do for ordinary furlough leave. We've had a number of questions about whether this is something you have to do come the 1st of July. It's not. So you might find that it works for you and it's something you want to take up, but actually it might be something that just doesn't work for your organisation. And if it's going to be necessary for your business that you keep those on furlough leave full time until the 31st October, that's absolutely fine. Just remember and bear in mind that the contributions to the government are going to be changing come 1st of August and then further in September and October. So that's a quick overview of the flexible furlough scheme. I'll pass you over to Ailsa in case she's got any more comments and to follow up with the second question.
Hi, Catherine, and thank you for that. Good morning, everyone, and thanks again for joining us, as Catherine said. No, I don't have any other comments on that, to be honest. I think it was very detailed. I think one of the things that's cropped out in some research I've been doing about the new scheme, or this being able to continue with the scheme after the 30th of June, and it was something to do with looking at basically the amount that an employer is claiming pre-30th June to the amount that they're claiming post 30th of June, and there's been some indication that post 30th of June it can't look higher, so you can't be claiming for more employees than you have been. So it's just something to watch out for when you're making those claims. So my question today is whether employees who care for or live with someone who's shielding can be compelled to return to work where they are uncomfortable to do so, either due to fear from themselves or for those that they're caring or live with. So the shielding requirements are limited to those people who fall into the extremely vulnerable category. All others, including those who care for those extremely vulnerable, such as family members, do not themselves need to shield. They may, however, take steps to be very diligent in their social distancing. Now that employers are starting to ask staff previously furloughed or working from home to return to the workplace in some form or another, they find themselves faced with either staff chomping at the bit to get back to work, and also others being a bit more reluctant to return to work, especially if they have childcare responsibilities, other caring responsibilities, or if they have regular or close contact or live with someone who's shielding. So it's a difficult one to face, and I think again there's no one size fits all, so it needs to be really assessed as these issues arrive. So I've mentioned before that those that live with shielding employees do not have the same restrictions placed on them as those who've been told to shield. There's therefore nothing preventing them from returning to work when requested to do so, provided the employer has done everything in terms of necessary checks for health and safety to make sure the workplace is safe. So in such circumstances, a request to return to the workplace will generally be a reasonable and lawful instruction, and one that the employer be required to follow. But that being said, employers should always talk to those employees who are anxious about safety and returning to work to try and resolve those concerns together. People's concerns can arise from fear of catching COVID themselves, or potentially from a fear of others catching it, particularly if that is a shielding member of their family and children in some instances. So in these cases, the options open to employers include arranging things like car parking to avoid use of public transport for travel, staggering working times, avoiding peak travel hours, or potentially peak times in the office. And there's also that option available to keep the employee who is living with someone who's shielding on furlough, but that's a decision for the employer and not something necessarily that the employee can dictate or demand. So if the employee still does not want to go back to work, the employer might enable them to take annual leave as an option, or potentially unpaid leave. But it's important to note that they're not obliged to do so unless, for example, the request is made for a period of statutory leave, for example, time off for dependents, where there's actual caring responsibilities attached to that person who is shielding. That might be one exception to the rule, but again, that's just a temporary period of leave so that arrangements can be put in place. But it's good just to make sure that you're aware of what statutory rights they do have in respect of taking other types of leave. But ultimately, a refusal to attend the workplace may result in disciplinary action. And while I'm sure most employers would not welcome such action and they'd prefer to find other means to achieve a more amenable return, it is important to remember that there will always be that requirement to resume normal practices under the contract. And where flexibility has been considered and offered by the employer, but then unreasonably refused by the employee, then there's really little in the way of other options for the employer but to take that disciplinary action and trying to actually enforce the terms of the contract. There is that commercial need for employees to come back into the workplace, especially where they're not able to work from home or they can't work productively from home. So it's a difficult task that employers face, and naturally ones that employees face as well. But it's important, I think, that both parties work together as much as they can to try and get a resolution that suits all. And I think considering flexible options is always going to be a good start there. But if that can't be achieved and the employee is digging their heels in, then recourse to the disciplinary procedure is going to be the best course of action. This might change, or it might become worse following the government's announcement on the 22nd of June in terms of easing shielding from the 6th of July and ultimately the advice to stop shielding from the 1st of August. So you might find that the situations that are facing people who live with or care for shielding employees actually applies to those shielding employees now, where there's a request to return to work. However, obviously you've got different discriminatory elements to consider there under the Equality Act for disability discrimination. So it's not part of the question today, but it might be one that we pick up on later. Catherine, do you have anything to add to that one before you crack on with the next question?
No, I think that was a really thorough and a good answer. I think, yeah, it's going to be interesting to see what happens when the changes come in next month and it's paused, the shielding is paused from the 1st of August. So we'll wait and see what happens. Just to finish things off, a final question we had was in relation to the easing of restrictions. We've got a number of businesses who have been able to open, but we've got another number of businesses who are able to open their doors from the 4th of July. And the question that came up in relation to that was where employers need more, need to bring staff back from furlough leave, but they don't need everyone. So how do they go about selecting who to recall and what are the considerations there? So in terms of that situation, I think that's going to be something that may affect many employers, even those who are currently are open for business, and as well as those who are coming back. And it's going to be something that's probably prominent as businesses continue with that slow return to hopefully some kind of normality. What I would say is you need to think about what your business needs are and what work you need to be carried out and what the demand and level of that is going to be. That is certainly going to be something that's going to change, and probably something that you're just going to have a wait and see and respond to that. And that's what, talking about the flexible furlough scheme, that is useful in terms of it's something you can draw upon as and when you need to if you've previously furloughed employees. What I would say is a first option is you could look at volunteers. It may well be that if you've got people who are willing to come back to work and ready, you might have the right number of volunteers. And if that's the case, great. I guess we know in practice it's not generally that easy, but worth a shot. If you've got a situation where you've got more employees than you need, then yes, you are going to have to look at either selecting from that group, or you can draw upon the flexible furlough scheme and have a rotating basis of people coming in and out. What I would say, if you use that option, think about splitting your members of staff into teams and organise your shift in a way that they'll remain in those teams whilst they're on their shifts, and that just helps from a health and safety perspective and contact that people are having. Again, in terms of if you've got not enough volunteers, again, you're going to need to think about some sort of mandatory selection process. And if you're looking at having to select employees, I think as long as the criteria you're applying is not discriminatory and you're applying it in a fair manner and consistently, it's going to be about what's necessary for the needs of your business. Think about what kind of soft skills you might need, certain skill sets, what duties, what roles do you need people to come in and do, and think about organising criteria on that basis. Also think about things that might come up are people's availability and them managing to come into work in terms of transport and the timings in which their shifts start and the resources in that regard and how that changes. Also, just drawing on what Ailsa touched upon, you've got the situations where people are still shielding, why that guidance is still in place, and those in particularly vulnerable groups, but also those who are still have children at home while the majority of schools remain closed, and some nurseries. So there does need to be consideration in that regard, drawing on from what Ailsa mentioned. What I would say is think about as well, if you're preparing this, think about risk of age, sex and disability discrimination. Think about the duty to make reasonable adjustments that will arise when you have employees who are disabled under the Equality Act, and bear that in mind. But it's going to come down to a fair and consistent approach when you're looking at using objective criteria. Also, just to keep an eye out for, it may well be that when you're going through that selection process, there is protest from either side. If you've got employees who are asked to come back to work and you have employees on furlough leave, particularly I'd say where you've been topping up the salary to 100%, if that's going to continue, it may be harder to incentivise some of the employees who are required to come back to work when staff are remaining on furlough and getting their full pay. It may be easier for those who are on a reduced salary. Also, on the flip side, it may well be an issue for those who are not recalled, and there may well be grievances raised in that manner. So just be prepared for that and responding to that in the appropriate way as and when they come up. So there are a number of things to think about, but it's going to be about a fair selection process with objective criteria. So that's just covering that query. I'll just check whether Ailsa's got anything to add before we close for this session.
Thanks, Catherine. It was just one thing really, and it was for when the changes come in August and shielding is relaxed, you might have some staff who have been shielding who are really, really keen to come back to work. And while, yes, at that time it won't be against government guidance where it is at the moment, if you've got either requests before that or after that, you've really got to consider your position and any refusal, because actually refusing to allow them to come back because of your own anxieties about, I suppose, making sure it's a safe working area for them to return to could be discriminatory, indirectly discriminatory. So if you're bringing everyone else back and not them because of the concerns you have, and they don't have the reluctance to return, then you could indirectly discriminate against them on grounds of their disability. So again, just one to watch, but that was it really. We'll pass back to David now just to wrap up, but thank you again for everyone joining us today, and I hope it's been useful.
Thanks both. Just want to remind you of the relevant and useful content that we've been providing and popping on our website, www.sintons.co.uk, should you wish to take a look. And this includes articles, blogs, podcasts, videos, and so on. You can also follow the employment team on Twitter @SintonsHR. If you'd like to discuss anything the team have raised today further, please don't hesitate to get in touch with them. I've just popped their details on the screen. Of course, if there's any other legal inquiry, please do not hesitate to get in touch. So as I mentioned at the outset, we're going to be releasing these sessions at 10 o'clock each Friday while there is interest in us doing so. So the next one will be next Friday at 10 a.m. and I will send the link round to you after the weekend. Hope you've enjoyed today. Thank you very much for listening. Continue to stay safe, everyone, and we'll speak to you next week. Thank you.